Hello and welcome to the Freedom from Religion Foundation's Ask an Atheist. My name's Rebecca Markert and I'm the legal director here at Freedom from Religion Foundation.
I'm Patrick Elliott, FFRF Senior Counsel.
And I am Andrew Seidel, FFRF's Director of Strategic Response, also an attorney.
We're coming to you live a little earlier this week because of a significant development in the legal world. By now, you've likely heard that the U.S. Supreme Court ruled last week that a 40-foot cross on town property in Bladensburg, Maryland, is not a constitutional violation. This decision and what it now means for the future of Establishment Clause cases and our work here at FFRF is our topic for today. As always, you're welcome to submit questions, which we will answer at the end of the show. Please feel free to submit them in the comments below or by emailing us at askanatheist@ffrf.org. As you may recall, this case was brought by the American Humanist Association on behalf of some local residents. FFRF and many of our sister organizations submitted amicus briefs or friend of the court briefs at the Fourth Circuit and at the U.S. Supreme Court. Patrick, you were an important part of that amicus brief writing. Could you bring everybody up to speed on what happened in the case, what the facts were?
Sure. There were a lot of facts cited throughout the many pages of documents that had been spilled on this, so I'm trying to focus on kind of the physical setting of what we're talking about. This is a cross case involving what basically stands to be about 40-foot tall Latin cross in Maryland, right outside D.C. We call it the Bladensburg Cross. And it was originally proposed shortly after, or after World War I as a memorial to certain people in Prince George's County. However, it was certainly thought to represent Calvary, Jesus' death and sacrifice at the same time.
That's what you mean when you say Latin cross. You mean a Christian cross,
right? As you'd see on top of any church, and so this was put on actually private property and completed in 1925 by the American Legion completing the project. And it was on private property until, I believe, 1961, because of the growing community surrounding this whole area. It basically became in the middle of a heavily trafficked highway. And so the state of Maryland took it over in 1961. And since that time, it's basically been on a traffic island. So it's this 28-foot tall cross on top of a huge pedestal, so it goes about 40 feet. If you're driving by, you can see the cross. What you might not see if you're closer up is there's a plaque dedicating it to the people of Prince George's County who had died in World War I. So the district court ruled that this was legal and it was permissible, and the Fourth Circuit Court of Appeals, which is where we filed a brief initially, found that it was an unconstitutional establishment of religion. And so that's kind of where we got before we ended up in the Supreme Court.
So it was originally dedicated to these 19 servicemen from World War I, but later in the 1980s, it was rededicated to all veterans. And that was a fact that seemed to be omitted from the majority opinion. And the majority opinion, Justice Alito wrote it, focused a lot on history. Andrew, you're a history buff. You just wrote a book about history and how it's used, particularly for legal precedent. Can you talk a little bit about how the court handled this historical guide for reaching their decision?
Yeah, it was really interesting because basically what the court did is they said, look, we're not going to worry about legal principle here. We're going to just look at how long this thing has been there. And it's really striking the way they abandoned legal principle and what the First Amendment means and the rules that the First Amendment establishes for government, and instead looked to history as a guide, I think was the phrase that Alito used. And it really is, in my opinion, a dereliction of their duty. We've seen the court do this before. They always do it when they want to uphold a religious practice that the government is engaging in. The first time they did it was in 1983 in the Marsh versus Chambers opinion, when they looked at legislative prayer at the Nebraska state legislature given by a Christian chaplain. They said, yeah, this is fine because the founding fathers were doing this as far back as 1774. And actually, Alito cited a 1774 prayer in this case, too, to show this long history of the government endorsing religion. But that also goes back to a time when we were still a British colony. We hadn't even declared independence, let alone had a constitution separating state and church, which is just one of the central flaws with using history. And the other central flaw is, and I'm writing something for FFRF about this week, is that the history is incomplete. I mean, they really cherry pick and whitewash history to get to the results that they want. And your example that you just gave of the court conveniently forgetting to mention that this cross actually was rededicated to represent all servicemen and women who have died is really important, because it doesn't. It only represents Christians. It doesn't represent the 1/4 of non-religious service members out there.
Right, and I think that was part of what was shocking to me in the opinion, was that they took a Christian cross and basically said, it can represent Christianity, but it can also evolve and represent something else, meaning a sacrifice of war. And that is probably the first time that that's ever happened in any court opinion, that this preeminent symbol of Christianity is now a symbol of war. So what do you think that means for other cross monuments across the country?
Right. I think that people are going to use this opinion and use that rationale to probably justify them. I think the reality is that we all, people who are non-religious and people who are religious, recognize that symbol. We recognize that as being, if you go into any church or you look at any Christian person who's wearing a cross or a crucifix, we know what that represents. That represents their religion. It's not necessarily representative of all of these other things. And so I just would echo what Andrew said, I think, on the cherry picking, which is kind of troubling in reading the opinion, even reading some of the facts that I mentioned. They highlight facts that are favorable to their side and just try to avoid talking about the other things. Like I mentioned, that this was designed to represent, like Jesus on Calvary is what one of the original discussion was about this symbol. So I think, unfortunately, it may be treated as a way for people to justify, the dominant religion in our country anyway. It may be a reason for them to justify using their symbols.
Well, and let's pause to appreciate the hypocrisy here, too, because you have a secular court with secular powers declaring that a religious symbol, the preeminent symbol of Christianity, now has secular meaning. And of course, our opponents, the religious right Christian nationalists, are declaring victory here. But if they were sincere, they would be up in arms about a secular court saying your religious symbol is not religious. I mean, that really ought to offend their deepest religious sensibilities. But because it allows them to use the machinery of the state to promote their religion, they're okay with it.
Right.
I mean, I was also troubled by, there's a lot of talk about the passage of time somehow justifying it. We've known for a long time what the cross has represented since its early use in, I don't know, the 4th century or whatnot, that this is something that has represented Christianity. So the passage of time doesn't necessarily fix a violation, in using a religious symbol that's affiliated so closely with one religion. I think that was another troubling aspect to the decision.
And that's going to open up all kinds of questions. So this cross was just shy of 100 years old, but how old is old enough? Right. When does your violation get the rubber stamp from the Supreme Court? Is 50 years? What about 40? What about 20? When is it old enough to be admitted into the pantheon?
Right. And there are a lot of crosses that were erected in the 1960s too. And are those old enough? My dad would probably say no. But one of the other things that was interesting about the opinion was Alito talked a lot about hostility, and how if they were to remove the cross, take it off of government property, that would be hostile to Christians in the community. Let's talk about that a little bit, because that's kind of an alarming trend that we're seeing in the Supreme Court precedents as well.
Yeah, this was one of the most troubling things for me when I was reading the opinion. I actually wrote an article for Slate because I was so upset by this part of the opinion. Alito essentially says that if we were to cure this violation of the Establishment Clause, that would be hostile to religion, and that would violate the Establishment Clause, which is this catch-22, meaning that courts have no power to cure very clear violations of the law. And if you were to apply that to other areas, 14th Amendment, equal protection, segregation, anti-slavery, allowing women to vote, you can see where the problems would come up with this very, very quickly. A court saying, well, actually, we can't cure the fact that this particular community won't let women vote because that would be hostile to the male voters in the community. I mean, it is ridiculous. And it also overturns precedent that has been in place since the Supreme Court's first decisions on state-church separation, the McCollum decision, the Abingdon v. Schempp decision, where the court actually said, like, of course it's not hostile to religion to cure a First Amendment violation. They went out of their way to say that. So, and that's something we're not hearing about, even in the talk of hostility, and even in my Slate article, this overturned precedent. 60, 70-year-old precedent, and the court didn't even bat an eyelid. They didn't care at all. So what other precedent are we going to see fall by the wayside here?
Right, and this decision's not even a week old, and so people are still combing through it, still like reeling from it and trying to figure out what the ramifications are. The one thing we do know is that they addressed the Lemon Test. Patrick, do you want to talk a little bit about what the Lemon Test is and what the court did in this decision?
Yeah. If people, I guess, that are out there generally are familiar with state church, maybe they're familiar with the Lemon Test. But really, it's just a synthesis of a number of principles in the Establishment Clause from a case in the early 1970s, Lemon versus Kurtzman. And so kind of three principles that the court was distilling from its prior cases. And the first being, for government action to be upheld, it would have to be, it would have to have a secular purpose, so not doing something with a religious purpose. And it would primarily be not to advance or inhibit religion. And then thirdly, not involve government excessive entanglement with religion. And so there's kind of these three separate areas of law that the court is addressing. Here, I forgot to mention in the facts, though, for the entanglement prong, is that actually this is costly to maintain. I think the state of Maryland has dedicated $100,000 that hasn't yet been spent to repairing the cross. It's
falling down.
Right, it's in disrepair. So excessive entanglements is the final third prong. But Lemon is kind of the enemy if you read some of these opinions and people criticizing Lemon. But really, it goes back to some of the cases Andrew was discussing, early precedent by the court of just saying, is the government doing something, with a religious purpose? We're not going to allow that. Or is the idea behind Bible classes in schools that you're going to instill religious teachings in children, and that is a religious effect, and we don't want the government, undertaking these religious means. So that's overall the Lemon Test, which is much maligned, but really we view it, I think, as just kind of a summary of a few decades of Supreme Court precedent.
And the court here, in this case, decided not to apply Lemon, but they also didn't quite overturn it. I think in later concurring opinions, I can't remember which justice it was, but it was something like, the Lemon Test has been shelved for now. So what is the future of the Lemon Test? Is it still helpful for lower courts? And did this case provide any clarity for cases moving forward in the courts?
Yeah, I think to me that was the big thing, I think there was this sense, especially from the conservative bloc on the Supreme Court, that going into this case, finally, you were going to get some clarity in Establishment Clause jurisprudence. And this case did nothing to help that. It was 87 pages, 7 different opinions. There was concurrences and dissents all over the map. I agree with this part, but not with that part. It really is not going to be that helpful, other than to say we're turning to history in some cases and ignoring legal principle, which is devastating in one way, but also because it's just the wrong way to practice law and to be a judge. I don't think it's going to be as big an impact as they're hoping. But mostly they did a terrible job in terms of giving that clarity to lower court judges.
Right, and it still seems that the Lemon Test, or at least the principles behind it, are valid for new things that the government would be undertaking and new displays that go up. There's this idea, at least in Alito's opinion, that was signed on to by the other justices, that the same analysis wouldn't apply to the government doing something like this today. So if I'm a lower court, I'm likely going to rely on the decades of precedent under Lemon Test rather than this decision, which doesn't really give a lot of guidance on how am I supposed to review a current display or current practice that the government's engaging in.
Right. We probably say this after every major Supreme Court decision. We certainly said it after Greece, involving legislative prayer, but I feel that this case is really just going to beget more litigation in trying to figure out what exactly the parameters are now.
Yeah, I mean, and there's so many contradictions in the case itself too. You know, Alito talks about how we can never know the original purpose of this cross. It could have been religious, it couldn't have been religious, we're not sure. But then goes on to say that the founders, of course, were totally okay with having all these religious elements in our government, and they knew they were religious and they meant them to be religious. And so you're saying that something 100 years ago we don't know, and something 225 years ago we absolutely know with certainty. And it's just, there's so many bad aspects of the opinion like that it's undermining itself.
Right. Well, one of the bad aspects of the opinion that I found alarming and seems to be sort of flying below the surface is this idea that minority faiths and non-believers in this country are being turned by the Supreme Court into second-class citizens.
Absolutely.
And our Bill of Rights, which is supposed to protect minorities from the majority, is being overturned. Essentially, that principle that the Bill of Rights exists to protect us. It seems like they're getting away from that. Alito even says that this cross becomes part of the community identity. And when you're saying that a Christian cross is the community's identity, you are ignoring all of those minority faith or those of no faith at all. And this seems to be a trend that started back in the 80s, continued with Greece. I'm really concerned about the effects of these decisions just making atheists into second-class citizens when we're seeing the demographics changing, where the non-religious are more and more the fastest-growing segment of the American population.
And it was interesting. I think Justice Ginsburg even referenced that in
The
portion of
demographics.
Yep, a portion of the opinion.
We have a graphic of it. We can show there it is.
And she's basically saying that 30% of the population in the U.S. Is no longer identifying is generally identifying as non-religious, and so I think somebody gets it at least. That there's this idea that they are acting like it's not a big deal for the community to be identified as a Christian community, and I think at least in the dissent there's some recognition that the country includes people who aren't religious or includes a more pluralistic society, rather than just giving lip service to it, which I think we've seen with maybe Kavanaugh's concurring opinion here, or pretending that how great it is that we're a pluralistic country and that we all are equal. You're not really doing that when you're issuing a decision, allowing a majoritarian faith to continue to dominate in some government aspect, what's on government land, what the government actions are. So I think the dissent certainly understood with Justice Ginsburg, understanding that there are people who aren't in this religion, and they are harmed when we're allowing this kind of thing to take place.
And the majority, or at least Alito's controlling opinion, certainly didn't understand. He said the exact opposite of what Ginsburg was essentially saying. He recognized that there was these changing demographics, but basically saying that as we become more and more religiously diverse, that we are going to be able to keep these symbols of historical significance up, which goes to what you were talking about, Rebecca. And I was shocked by that community standards language. The idea that all of a sudden it is up to the majority to decide what is constitutional, you're absolutely right. It completely undermines the very purpose of the Bill of Rights, which exists to protect the minority from the tyranny of the majority. And I was shocked when I was reading that all, and it was throughout community standards, community.
Well, and then this goes back to Justice Kavanaugh, who is new to the court, and we're seeing more and more of what his views are. But he talks about the courts not being the final arbiter of this situation. Instead of going to court to fight these battles, he says that we can fight them in the legislature. And we've certainly been doing that. We do have here at FFRF our lobbying arm that is growing, and we've gotten our attorneys to go out to Washington, D.C. and educate Congress. And we do see that is an important aspect of fighting for the rights of the non-religious here in America. But that also seems to undermine the purpose of the Bill of Rights and the purpose of the courts in protecting minorities under the Bill of Rights. And that was also a very alarming section of the opinion that I read.
No, I agree completely. I had a law professor who said that we always think of the Supreme Court as this, great defender of civil rights, but really they're not. They're the last person in on an all-team tackle. That was the way he liked it. They run in and jump on top of the pile and say, "Look what I did!" And here you have they're doing something even worse than that. They're throwing a flag and saying, "Yeah, this is completely." And to me, this is one of the most poorly reasoned and just decisions bereft of legal principle that I've seen in a very long time.
Right. We do have a lot of questions, but before we get to them, I don't want our viewers to be left with all doom and gloom. I would like to talk about how we're going to be fighting the ramifications of this decision and where we go from here. I know that I am working with the American Humanist Association on a cross case in Pensacola, Florida, which is still pending before the U.S. Supreme Court. I didn't see it on the order list today, but that involves a large Christian cross in a city park in Pensacola, Florida. It was also erected in the 1960s, was used for Easter services, has a lot of religious motivation and purpose behind it. That's still pending in the courts, and I think that there is still an argument to be made that this is different because Easter sunrise services still happen at the foot of that cross every spring. So we're still going to move forward with that case and fight like hell to make sure that that is the 11th Circuit's opinion that this was unconstitutional is upheld. We have the Lehigh seal case in Pennsylvania.
Right. We have a case regarding basically a government symbol, which I think is very different than a monument that's on government property. There's the county in Pennsylvania that has a cross as the center of its seal, and we won that case in district court, and it's currently on appeal. And I think, like you said, that we're still fighting that case, and I think we have very much a different set of circumstances, and unfortunately for Establishment Clause cases, that's how these tend to go, which is minor differences in facts might make a big difference in the ultimate outcome. So I think it's not all gloom and doom. I think the Establishment Clause still has meaning and is still enforceable. But this may be an additional barrier for certain cases that are, that fit within the facts that were here.
And we certainly have been able to cabin and narrow the decision. After the Greece case involving legislative prayer, we took the Chino Valley case. Do you want to talk a little bit about that?
We took a school board prayer case after the government expanded legislative prayer at city and county meetings, and we made sure that didn't apply to school boards. And we're going to see the same thing happening here, where the Supreme Court was supposed to go in and tidy up the law and make this understandable for everybody, and they threw a grenade into it instead. This is a huge mess, so there's a lot of opportunity for us to limit the damage and really, as you said, cabin the effects of this. And because they relied so much on history here, they actually really hamstrung themselves in terms of having a far-reaching opinion, because now it's going to be a historical fight in every one of these cases, and history is not on their side. I mean, Alito got a lot of history wrong in the opinion too. So I think they've done themselves a disservice if they were trying to one, add clarity, and two, sort of expand this area of the law. We're going to win this fight in the end for sure.
Right. We could talk about this for a long time, but let's get to questions from our viewers. Paul Breen asks, so the longer that something is illegal and allowed to exist, it can become legal?
Yeah, I mean,
essentially.
I think Paul gets it. I mean, as a matter of law, I mean, just as lawyers and as judges, this is a principle that we can't allow to stand. Obviously, our courts have made decisions on any number of constitutional issues, especially, both in the First Amendment, the Fourth Amendment, all of these decisions that have come out, the things that we allowed for a period of time and later on recognized or had a court finally decide is illegal. That's a poor principle to live by, that the things that we've allowed for a long time we're going to say are okay. I think that is a lesson in part to take away from this, that some of the judges are unwilling to enforce the Establishment Clause on some of those really old or older violations that have been taking place since the 1920s or the 1960s.
Yeah, I mean, to me, segregation is the best example of this. I mean, it was before it was overturned, there was 100-year-long history of segregation. Before that, there was how many hundreds of years of slavery, and that was not upheld because of the long history of segregation in this country. And to think that that was a possibility is nuts. So if you apply this rationale outside of the Establishment Clause context, it becomes very clear how deficient and bereft it is. And I think a lot of lower court judges and a lot of state court judges are also going to see that this is just not a guidepost for them to making their own decisions in these cases.
Right. Wendy Bruning asks, instead of getting it removed, can we erect symbols from as many religions as possible around it?
I mean, I have strong opinions on this, I guess, just because, it's a tactic that has been tried. There's actually a Supreme Court case, I think it's Sumum versus City of Pleasant Grove from 2009.
Wrote the opinion in that one.
Yeah, Alito unfortunately wrote the opinion in that, where a group challenged to put up the 7 aphorisms when there was a Ten Commandments monument and this property. And the court basically said, no, the government gets to decide what monuments it wants to place on its property. That's government speech. And so as a legal question of just do you have the right to put up a permanent structure or monument, or could we do that? No, I don't think that they would be required to do that. I think there's merit in asking. Honestly, I think diminishing the prominence of one religious symbol by including others, or just pointing out the problem with making these tough decisions on what religious symbols or what displays we're going to allow. So I do think there's merit in asking and advancing that argument. But I'm opinionated as a legal perspective. I do not think that that's an end result that we can actually think we could enforce, that they would have to place a display.
Right. They still get to decide what they put on their property.
And there's nothing in this opinion that changes that. And in fact, the community standards language that we talked about undercuts that. So there's other language in the opinion that suggests that no, that would not be permitted just because you all of a sudden ask. As a tactic, it is a little, I agree with Patrick, it has its place. My favorite was the Santa Monica park that opened up the forum for, they had a nativity, and then they opened up 13 spots, and they had a lottery for who got the spots, and atheists got 11 of the 13 spots and put up displays, and then they shut the whole thing down. So it can be very effective, but not here.
Right.
With permanent, and being that it's a permanent structure, I think for temporary displays, it's a much more a tried and true tactic that you probably would have the right to try to do something like that.
Right. Cornelia Campbell writes or asks, is this decision final? Can it be appealed? No, it cannot. This is the U.S. Supreme Court. It's final.
Yep.
Right. I mean, unless you take Kavanaugh's suggestion of going to the Maryland legislature or the Maryland governor and asking for this to be resolved, because honestly, it should be on private property and not on public property. There's probably not a huge prospect of winning that argument, but there may come a point in time where there's a government in Maryland that would be willing to consider moving this to private property or somehow resolving the issue. So that's the only real appeal that can take place. The Supreme Court is obviously the final word on the legal issue here.
And I'd like to see local secular groups starting to take those on and looking at monuments near them that may have religious significance and start trying to get them put on public property or removed. But the other thing, too, to mention about this is that the Supreme Court can change its mind. It can overrule itself. I mean, there's one instance where it changed its mind in 3 years, culminating in the Barnett case, which was the case that allows children not to be forced by the government to stand for the Pledge of Allegiance. And that was just a quick 3-year turnaround. A lot happened in the country then, but a lot is happening in our country right now. So you never know where we could be.
Right. And we have a lot of young people who are non-religious who are going to be graduating from college, graduating from law school, and becoming judges. So I do feel that this will be overturned someday. So 2 final questions. Stephen Shefkick asks, shouldn't we differentiate between actively promoting religion and something of historical significance?
Well, the Supreme Court seems to think so. But again, to me, a 40-foot tall Christian cross is not a close call. I mean, it is a 40-foot tall cross that is meant to represent Christianity. It's selected for the World War I memorials, the individual memorials, because it was commemorating Christian soldiers who wanted that when they died. It's not anything other than a Christian cross. And again, I think buying into that line of argument is also buying into what Alito did, which is essentially scare the country with this idea of a bulldozer driving into the cross and knocking it down, when really there are other solutions to it. You can make that memorial a secular memorial. You could transfer that land to private citizens so that the government endorsement evaporates. There are a number, and that's happened in cross cases that the Supreme Court has dealt with before.
Right. I mean, you can remove the cross. It's hard, but you can do it.
Pick it up with a crane and put it in front of a church.
I do like what Ruth Bader Ginsburg said. The presumption should be that a large Christian cross on government property is unconstitutional. It can be overcome. We can still litigate that, but the presumption should be, yes, this is unconstitutional, because people see it and they think Christianity. They don't think war veterans.
Yeah. And again, with the history, you're getting into cherry-picked, whitewashed waters if you just assume that it's got this historical significance.
That's right. So Pamela K. Vanderblumen asks, how does a cross or a Ten Commandments monument take on a secular meaning?
When the court says it does.
Right. I mean, in terms of how the court has viewed this, Justice Breyer wrote an opinion in 2005 on a Ten Commandments case, and I think I disagree with him there, but he basically was talking about the use of the monument in the Texas Capitol grounds, among all these other things, related to law and government, and the original purpose of putting that one up didn't have in his opinion, the blatantly religious promotion as I think somebody putting it up today would. So that's his opinion. I think the reality is when you put up the Ten Commandments monument or you put up a Christian cross, you're doing religious expression in doing that. It's not a secular expression when you're doing those. But that's how some reasonable justices have found that, or using it as a symbol for law giving. I think in the Supreme Court, that's a horrible example that everybody cites, is that there's all these lawgivers depicted, and there's Ten Commandments depicted there, not with the text or anything. But that would be an actual secular meaning, I think, of just that among all these other
they always forget
symbols.
to mention that Muhammad is just right. Opposite Moses there, too. But for me, it goes back to the hypocrisy that we were talking about before. You have a secular court declaring that a religious symbol is secular. And Alito, in his opinion, goes out of his way to liken groups like AHA and FFRF to the French Reign of Terror, saying that we're going around desacralizing all of these sacred sites. And that's exactly what he's doing in the opinion. He's saying that this religious cross is not religious anymore. And he is the actual government doing that. And we've seen the court do this before when they want to uphold religion in government endorsements of religion. Within God we trust, one nation under God. I think I wrote for FFRF, for Free Thought Now, our blog, I think it was called The Christian Hypocrisy of In God We Trust, where I kind of lay this out. And so we've seen it happen before, we'll see it happen again, but I think you're right that eventually these are all going to get overturned.
So you're the Director of Strategic Response. Earlier, you said that you would like to see local groups, local secular groups get involved. How can they do that? How can they get involved with FFRF? Who can they text? And what can they text?
One thing you can do is you can text FFRF to 52886, and that will put you on our action alert list when there's something going on in your area. You will be notified right to your smartphone. For instance, when there's a terrible judge that's being voted on in the U.S. Senate, you'll know. You won't know, though, about a monument that might be sitting in your town square. We can certainly help people get active on that. But if you text FFRF to 52886, that's a great way to start getting involved. And, of course, joining FFRF. We help provide you with the tools to fight these battles, and a lot of backup and a great community, 31,000 members to do that too.
Right. And I told the attorneys last week, this is when our job becomes all the more important because we're fighting for minorities here in this country, and we're going to continue to do that. We truly believe that we can't have religious liberty in our country unless our government is free from religion. So that's it for today. Please join us next week at the same time, same channel. This program will be re-airing again on Wednesday if you'd like to tune in again.